Well, welcome back to the hot seat. I'm delighted today to be joined by Victoria Grogan, who's a partner from Collas Crill here in Jersey. Welcome, Victoria.
Thank you, David. Thank you for having me.
So we're on a beautiful sunny day here in Jersey.
Yeah.
We've got the PCD dinner tonight, which you're coming to.
I am, yeah.
But for PCD members who've not met you before, it'd be great to hear a little bit more about your background and your focus at Collas Crill.
Okay. Thanks, David. So I have been at Collas Crill for 7 months now. So I joined in November last year. My background is primarily wills, probate and estate planning and mental capacity. So I have worked in that field now for 16 years and have done a number of exams and qualifications on the way. I qualified as a Jersey advocate about 4 or 5 years ago now. And then have been with Collas Crill, like I said, for 7 months.
Fantastic group of colleagues as well.
Yes.
Angela Callan in
Indeed.
Guernsey and further afield. I mean, have you found you've interacted with other offices in the group so far in your time?
Yes, I have actually. I've been very lucky because when I first joined the firm, I had the privilege of being put forward for a management training course that was attended by partners from all the jurisdictions. So Collas Crill have offices, Jersey, Guernsey, BVI and Cayman. Yeah. And I was very fortunate to be put forward by Kellyanne, who heads up the international private client team in the Jersey office, to attend that course in Cambridge for a number of days. So that gave me the opportunity, before I'd even joined officially, to meet with other partners within the business who ordinarily I probably would not have met at this point. So it gave me a real advantage, I think, on joining the firm, that I'd already met a number of other partners in the other jurisdictions, and it gave me a real good feel for the firm as well, even before I'd even joined. So
fantastic. Well, exciting times to be building out that area, isn't it?
Yeah, absolutely. It's something that I've really enjoyed doing, developing a team. And when I joined Collas Crill in November, I also joined alongside 4 other people. So we had 2 associates join from Onshore law firms at the same time, a legal assistant from a Jersey-based firm, and a business assistant as well. So there were actually 5 of us who joined the private client team all around the same time, which is really nice as well. So I wasn't the only newbie, but I think it really shows Collas Crill's commitment to building out that service line offering to our clients, to growing and developing the future of my team. So
Super.
Very exciting time
Great.
to be a part of the firm.
So things developing in your field of expertise. Perhaps you could just run us through some of the key things that are changing and the impact for clients.
Of course. I mean, it's an area of law, wills and estate planning that is constantly developing. There's constantly new cases, new case law. So very exciting. And actually over the last few months here in Jersey, there have been some particular new developments, new laws, new guidance issued, which has been really interesting for myself as an advisor and as a practitioner. So the most recent one is the increase of the small estate exemption procedure over here. So this is on the estate side of things. So previously, the small estate exemption limit was £10,000, which meant that for a non-Jersey domiciled person who had assets in the island exceeding £10,000, when the executor was dealing with that estate, you had to get a grant of probate. Now, the small estate exemption procedure didn't actually apply to estates where the deceased was Jersey domiciled. So there was no small estate limit. You had to get a grant of probate, even if that deceased person owned assets worth a couple of £100 over here. And this is because they have very strict rules over here, known as the intermeddling rule, which means that a person cannot deal with a deceased person's assets at any point after their death until a grant of probate has been issued.
So would that affect deposits in bank accounts? And what kind of assets for a foreign person would typically be affected?
So yes, generally it is deposits in bank accounts. However, the increase, so the amendment that has recently been approved by the States of Jersey increases that £10,000 limit to £30,000. In the profession, we've talked about increasing this limit, and there's been a number of consultations on it for a number of months now. It was meant to come into force last year, but it was approved on the 23rd of May this year that actually, finally, the small estate exemption limit will be increased to £30,000. And it's not just for non-domiciled deceased estates. It also applies to locally domiciled estates as well, which is really helpful because
ease the burden of administration.
It does, it eases the cost for beneficiaries, and it means that actually funds can be released to pay for things such as funeral bills, any outstanding care home invoices, any bills immediately. So the banks have that ability now. When the new law comes into force, they will have the ability, to actually release the money for that without a grant of probate having to be obtained. So it just does, like you say, David, ease the burden on beneficiaries. However, it is important to note that there are a number of circumstances that must apply in order for the small estate exemption procedure to be utilised. So firstly, there must be no caveat in place, which means that nobody has put a restriction on a grant of probate or being obtained in that estate. So that is the one thing that will need to be checked. And secondly, the person who is applying to the asset holder to take those assets, which have a value of under £30,000, must confirm to the asset holder that the asset holder will no longer have any liability in respect of those assets. So the asset holder has to have some assurance, of course, that in releasing the £30,000 to the person that is applying for it, there's going to be no repercussions for them. If they have any concerns in that regard, then they should always insist that a grant of probate is still obtained, even if a beneficiary is saying, look, it falls under the £30,000 exemption limit, is only £25,000. If the asset holder has any reason for concern, it's completely up to them. They are not obliged to release the money under £30,000. They can still insist that a grant of probate is issued. And I think for the asset holders over here, it's really important for them to be aware of that. Just so they know the risks. They must have certain assurances that the money is being released to the correct person.
And onshore advisors might see this popping up in an estate they're dealing with in the UK, where there's a balance and actually up to £30,000. It's a meaningful amount that needs to be dealt with. And so I suppose you would often work with onshore advisors who are trying to pull together something for them.
Yes, so a very common area of my practice is dealing with what's known as fast-track estates. So this is where a person has died domiciled in Britain and a corresponding British grant has been obtained. So in estates that fall into that category, the court over here will issue a grant of probate very easily. They accept the British grant on face value, and a postal application has to be made to the court over here rather than an actual court appearance, as you have to make in other estates. So yes, it will really help onshore lawyers when they deal with estates where there is a Jersey asset of low value, because it means that they won't need to go through that process. Obviously, it's not great for myself. That's quite a large amount of what we do. Not just myself, but Jersey practitioners. Fast-track estates are, bread and butter of what we do, and the increase from £10,000 to £30,000 is going to see quite a lot of that type of work now being dealt with by the executors in Britain directly, without the need to necessarily have to instruct a Jersey lawyer.
Okay.
So yeah, that's one of the recent updates. So that law hasn't come into force yet, but it has been approved to come into force, and we anticipate that it will be in force at some point shortly. One of the other fairly recent updates is that my team, myself and one of my associates in my team at Collas Crill, we've recently made an application to the Jersey court on behalf of our clients who wanted to disclaim a gift of immovable property that had been left to them by the will of their son, who had died suddenly. Now, they were both in their 70s, they were very well off themselves, had property themselves. They did not want to inherit his property, and they preferred for it instead to pass to his brother. He had no spouse, no children of his own. They just had no need to inherit this property, and they thought it made good estate planning sense for it to pass directly to their other son. Now, under Jersey law, there's nothing actually in the law to say that you can disclaim a gift of immovable estate, which is completely contrary to the law for movable assets. And Jersey has a very clear distinction between immovable and movable assets over here for succession purposes. So it throws up some quite interesting nuances, such as this one. So the law allows a person to disclaim a gift of movable estate under Article 26 of the probate law, but there's no similar mechanism in the law for a person to disclaim a gift of immovable estate. So we recently made an application to the court to ask for our clients to be able to do that, which was granted. So that was really exciting to be a part of. A bit of new law there, David. So
fantastic.
That was good. And also on another point in terms of new developments, the court over here, they issued some practice guidance notes in terms of foreign powers of attorney. So under Jersey law, it has, for a long time, it's been possible under the Royal Court rules to register a foreign power of attorney in chambers before the judicial greffier over here. But there was no real practice direction in respect of how that was actually done, what the process was, what the documents were that were needed.
So that might mean someone living abroad could have the power, or how does it? What would it look like?
Correct. So this would apply for, let's say, a UK domiciled person who has assets over here, but they have a UK power of attorney that appoints a family member as their attorney. In order for that power of attorney to be effective over here in Jersey, it has to be registered with the court.
Right.
And the court over here then issues an act of court, which gives that attorney official authority, and it's that act of court that is then given to the bank, the asset holder, so that they know they can accept the authority of that person. So it's always been possible to register powers of attorney, but there's just been no real guidance on it. And that has now changed with the issue of a number of practice directions, which is really helpful. It clarifies what we need to do, and it means that it's easier for us to advise onshore lawyers or other connections, other foreign lawyers, the people that we work with. It's easy for us to advise exactly what they need to go through that process. And
do powers of attorney get overlooked, do you think, sometimes? Not enough people do a will, but
no, I think powers of attorney are even worse, to be honest. And it's something that we are really trying to encourage. So when a client comes to us and says that they want to do a will and put a will in place, we always say to them at the same time, have you thought about powers of attorney? It tends to be something that an older generation think about more than a younger generation. However, it really is a step that anybody with an asset should take. You have to have capacity in order to put a lasting power of attorney in place. As soon as that gets called into question, you can't do it. It's too late. So that's why we as a firm, and I think the practitioners who practice in this area in Jersey, are really trying to encourage more clients to take that step and put lasting powers of attorney in place. Very important. It's much better to have one in place and not need it than need it and not have one. Because, of course, as soon as your capacity is called into question, you can't put a power of attorney in place anymore, and a court process has to be gone through in order to appoint somebody to look after your affairs. And the person that the court might seem suitable and the person that they want to appoint might not necessarily be the same person that you would have wanted to appoint yourselves. So it's really, really important at the minute. But one particular interesting point to note over here for our clients and contacts is that even though there is now the ability for Jersey resident people to put Jersey lasting powers of attorney in place, it's not possible for a non-resident person at the moment to put a Jersey lasting power of attorney in place. So that's why it's so important to have the knowledge that a foreign power of attorney can now be registered over here in Jersey, and to have that clarification in terms of the guidance and what is needed, the cost of doing it, and what the court will actually require in order to do that.
And I mean, on the importance of having a Jersey will,
yes.
I mean, what do you think holds people back from putting these things in place? Is it just simply, an international private wealth client has assets here, they don't realise that that there's a need for something covering those? What is it that you think
I think
stops the message getting through in a way,
we see it so regularly where somebody will have international assets and they have one will that governs all of those assets, and they think that that's sufficient. In some cases, it may well be, but a lot of the clients that I deal with they think they've done it, they've put the will in place, don't want to take any further steps, they're happy with their succession plan. They don't necessarily tend to look at the bigger picture as to actually, on your death, how easy will it be for your beneficiaries to deal with your estate when you've got assets in multiple jurisdictions? And having a Jersey will can really make the administration of Jersey assets after the death of a person so much more straightforward. We're very lucky in that we have a very swift and efficient probate process over here. The registrar is excellent. She's personally known to most of the practitioners here in the island. Very easy to contact. The court's a 2-minute walk from most of our offices, so it's not something that you have in many jurisdictions. We're incredibly lucky in that regard. And once we make an application for a grant of probate with a Jersey will, you can have that grant of probate issued within about 3 to 5 days. And when you compare that to other jurisdictions, such as the UK at the minute, has a delay in the issuance of grants of probate which is approximately 5 to 6 months. So having a separate Jersey will in place can really speed up the administration of Jersey assets following the death of the person who held those assets.
But I guess all advisors have a role to play, don't they, in prompting, so whether you're the bank and asset manager, whatever you're approaching it from, to prompt and remind people to make sure that there's appropriate arrangements, even if it's not on their day-to-day. It's so important, isn't it?
Yeah, just to have the conversations and just to say, look, you've got a Jersey asset. Have you thought about having a separate Jersey will to cover just your Jersey assets? These are the reasons why it would be beneficial. And I mean, it's an outlay of a low cost, really, when you compare it to the peace of mind and the saving that you will make in the long run, because your estate will be administered so much more efficiently. And it's much easier for the beneficiaries as well. And because the process here is so quick, it can enable Jersey assets to be released really fast. It gives estates liquidity. It can help to pay tax or bills, debts in other jurisdictions. So it's definitely worth considering. And again, something that we do try and encourage extremely regularly. And
keep under review.
Yeah, exactly. Keep under review.
And the type of advisors you might work with here, I guess if you get high net worth relocators, they need to have a look again, don't they, at all their affairs, or they're buying assets here, moving from outside in.
Yeah, absolutely.
What sort of advisors do you tend to find, phone you up with new clients?
So lots of tax advisors, UK and local. I think tax is one of the main driving points for people relocating to the island, obviously, especially for the high net worths. So a lot of the initial contact point will come from their onshore advisors or their tax advisors. And that does drive their whole relocation to the island. But as a result of that, they then need to look at their succession planning. They may have wills in place previously from when they were resident or domiciled in another jurisdiction that might not necessarily work for Jersey purposes. A prime example of this is that if you buy a freehold property over here, in order to have a valid will to cover that property, the will has to be read out loud to you by a Jersey advocate before you sign it. That's not something that happens typically in the UK or other jurisdictions. I mean, you're not going to get a Jersey advocate reading out a will. It's very, very rare. So for a person who does move to the island, again, it's something that needs to be done because their current will is unlikely to be valid to cover Jersey property because of this strict requirement that it has to be read out loud to you by a Jersey advocate. It's something that as a Jersey advocate I do very regularly. Not my favourite thing to do when the will is about 20 pages long, but it has to be done in order to make it a valid testamentary document to cover Jersey Realty. So again, that's not something that high net worth clients moving to the island would be particularly aware of, and that's my responsibility as a local advisor to make sure that they have that understanding and that their advisors have that understanding as well.
Great. And well, we've got our networking dinner tonight. We've got 180 guests down at the L'Horizon later on tonight. You're looking forward to the event tonight?
I am. It's particularly well attended this year, I think. Seems to be a lot of people coming here from onshore. Lots of people in the island for today and tomorrow as well, doing business development. It's always a great venue as well, the L'Horizon, and I think the tide will be high in time for the networking drinks beforehand. So I think it will be a wonderful event this evening. And I mean, you always throw a great event, David, so very much looking forward to it.
Fantastic. Well, look, lovely to talk to you today, Victoria.
Thank you for having me.
Look forward to seeing you tonight.
Yeah, absolutely. Thanks very much, David. Thank you for having me.